started for the people in here. For whatever reason, this, which is normally where I keep, of course now it works. Please hold. It decided it didn't want to work today. So give me a second, sorry. While I get this pulled up, I hope everybody has done their People versus Larry Flynt discussion posts. If you haven't responded to 2 of your classmates, remember you got to respond to 2 of your classmates, not just 1, otherwise you don't get full points. Then please do so this evening or tomorrow. I probably won't check it before tomorrow, and we'll kind of let that slide. So I cannot tell you how many times during semesters people have only responded to 1 classmate and then been surprised when they don't get full points. So please make sure that you do that as well. I will also be posting tonight the only legal analysis we have during the semester. It'll focus on obscenity and indecency. It'll be due Sunday, so you guys have a full week to do it, and I will put lots of helpful information up there for you guys to look at. All right. Today, we are focused on the media and football, right? The media as a news gathering and news dissemination organization, entity. So I actually like to start by returning to our conversation about the First Amendment. So for our first class was, I think, on Inauguration Day. I think it was on the 20th. So for over a month now, we have been focused pretty much exclusively on the first freedom guaranteed by the First Amendment, that is the freedom of speech. However, as we know that there are 5 freedoms guaranteed in that amendment, one of them, the one immediately following speech, is of the press. Now, what does this clause mean? Right? There are lots of differing viewpoints on this. Is it referring to press as we understand the press today? This occupation of being a journalist, the press corps? Is it literally the freedom of the printing press, as some people have theorized, right? So when the Founding Fathers wrote the First Amendment, they said freedom of speech and freedom of the press, essentially freedom of speaking and freedom of writing. And this is going to be a pretty important question that the Supreme Court, rather unhelpfully, has not answered fully. So let's look at what that means. So I'm going to start with the hypothetical, actually. And I want people both here and online to participate if you can. The hypothetical is that the mayor of Springfield, Joe Quimby, has started taking bribes from organized crime, Fat Tony and his associates. Now, one of the mayor's aides, kind of aghast at this corruption, has decided to divulge this information to 3 individuals, who then report it, who then disseminate it further. Number 1, this is Kent Brockman. Kent Brockman is the stereotypical nightly news journalist, right? The Walter Cronkite comes on every evening at 6 p.m. and reads you the news. For the purposes of this hypothetical, he is a rather accomplished journalist. He has 30 years of experience. He has a journalism degree. He sits on the board for a journalism trade group, right? This is as journalism can get. Traditional press. Number 2, you got Lisa Simpson, who for the purposes of this is going to be 18 years old. Not a minor, so don't worry about that. She is an aspiring journalist. She has started her own personal magazine. Now, Lisa has no formalized training and holds no degree in journalism. Person number 3 is just Barney Gumble, right? Barney Gumble's a local drunk who is next to the mayor's aide at a local tavern, and the aide drunkenly confesses to Barney, and Barney posts what he heard from the mayor's aide on Facebook. Now, all of these people operate on the condition of anonymity, right? They don't report who the mayor's aide is. They don't report how they got this information. They simply say, an anonymous source has told me this about the mayor. So the question I have for you guys is the following. Now, the Department of Justice, local cops, they're obviously going to be concerned about corruption in local government. So they set in a task force. And as part of this task force, they issue subpoenas. Now, subpoenas are essentially a court order to do something. A court order to produce yourself, a court order to produce documents or information or recordings, right? Subpoena is essentially a court telling you to do something you got to do. A grand jury can subpoena people. They can say, you got to appear, you got to testify. And they subpoena these three people. And they ask them questions. And one of those questions is, who revealed the information? Who told you about Joe Quimby? So we can interview that person. Now, does anybody know what happens if you were, and these three people say, I refuse to answer because of the protections afforded to me by the First Amendment? Does anybody know what happens when you fail to answer a question that is put to you while under oath? Do we know what the contempt, exactly, right? Contempt of court, contempt of court. Does anybody know what the punishment for contempt is? Like, we kind of all understand what the punishment for murder is, right? 25 to life, or you get a speeding ticket, you got to pay your little $10 fine, whatever it happens to be. Do we know what the punishment for contempt of court is? It's whatever the heck the judge wants it to be. Because, and I think I took this part out, because contempt of court is not intended to be punitive, okay? I speed, I go 95 in a school zone, they're gonna arrest me, they're going to throw me in jail, and they're gonna charge me a whole bunch of money. It's intended to punish me. Don't do that again, you're endangering children. But they're not expecting me to not, they can't, like, I'm not a time machine, I can't go back and stop myself from speeding. If you are charged with contempt of court, you can be thrown in jail and you can be fined, not because they're trying to punish you, at least not primarily. Typically, contempt of court is to, at least in this context, is to persuade you to do something. It is persuasive. I'm going to keep you in jail until you do what I tell you to. Then you're fine, and I'll let you out. So that's what contempt of court means. But yes, it's forceful persuasion. Persuasion with use of the IRS and handcuffs tends to be pretty persuasive. You don't see it as much as you used to, but we'll talk about some instances in which you do. And actually, like, there are, you'll see it actually a fair amount in local criminal court. When I worked for the district attorney's office when I was in law school, you would see judges cite people for contempt. I saw somebody be put in jail for a couple days for contempt because they refused to testify. So it can happen. It doesn't happen all that much, especially not recently when it comes to media. But anyway. Does anybody, and I actually need to talk about this before we get to the hypothetical, does anybody know of a situation in which you can say, you asked me that question, but essentially, screw you, I'm not going to answer it. And it's fine, they can't charge you with contempt. Anybody know a personal situation with that? There's a very famous Chappelle Show sketch about it. It was a very
Could be wrong, but is it pleading the fifth?
Plead the fifth. 1, 2, 3, 4, 5th. You cannot be held, you cannot be required to be a witness against yourself. It's also known as the right against self-incrimination. So there is basis for this, right? They're not going in and like kind of having this brand new legal theory. I'll talk about in a second in which some other instances in which you can avoid having to testify. But anyway, let's refer to the hypothetical just for a quick second. Kent Brockman, Lisa Simpson, and Barney Gumble all say, I am a journalist. I have the protections of the First Amendment freedom of the press. Therefore, you trying to make me testify and reveal my source is an infringement on that freedom of the press. Go kick rocks. Does anybody here, do you think anybody has a strong argument that they should not have to abide by a subpoena because they're a journalist? Right, Ben Brockman, right? The journalist that is a journalist, right? If you can think of, there is no more symbolic of the institutionalized traditional press than Ken Brockman. Right, or at least a professional journalist, right? It is their job. In the same way a doctor can refuse to testify against a patient because it is their job. What about Lisa Simpson? She considers herself a journalist, right? She's got a newspaper. She's got a, little newsletter that she puts out. Do you think that she can avoid to testify? She can say, no, I'm a journalist. You can't make me testify? Or are Ken Brockman and Lisa Simpson different somehow?
Private our newspaper is not really known to the worldwide. It's known to our community, but it's not known to a vast majority of people.
Right. There aren't a lot of people going to the red letter, the red dress press to get their news on the everyday goings on in the world, right? So you're absolutely right. There is a difference between what Ken Brockman does and what Lisa Simpson does. The question becomes, is it a material difference? What about Barney Gumble? Somebody think Barney Gumble can say he's a journalist? Some guy who's getting drunk in a bar posting stuff on Facebook? Not in the traditional sense, right? The answer is none of them. None of them get to refuse to testify, at least according to the Supreme Court. But let's kind of see how we got there. There are two schools of thought here. And it is a school of thought that I think both has some amount of persuasive power. Right? I don't think either one of these is particularly unmoored from logic. And both of them come from Supreme Court justices, who, again, are significantly smarter than I am. But let's start with Justice Potter Stewart. Now, Justice Potter Stewart looks at the First Amendment, and he says, we got this press clause there, right? We have freedom of speech, and we have the freedom of the press. When the founders created the First Amendment, they inserted that language in for a particular purpose, which means that the founding fathers, when they wrote the First Amendment, must have included some sort of special carve-out for the press, the institution of the press. Because otherwise you would just say freedom of speech and leave it at that. And this is a method of constitutional interpretation called avoiding a constitutional redundancy. Every single word in the Constitution has a meaning for having been there, right? There are no just throwaway words in the Constitution. And if you read freedom of the press to have no special meaning, then you essentially are arguing that the James Madison, when he wrote the First Amendment, and the states when they adopted it, just adopted filler language, filler words. And not only that, but there's a policy behind it, right? It's not just them looking at words on a page and coming to a conclusion. The press has a unique role in the government. It is how we, as the population, know about what our government is doing, because the government's not always going to tell us what it is that they are doing. Richard Nixon sure as heck would not have told us about Watergate, for example. And it's why the press is commonly referred to as something called the Fourth Estate. The Fourth Estate is kind of going back to our Schoolhouse Rock days. We have three branches of government. They have co-equal checks and balances on each other. So we have the legislature, we have the executive, and we have the judiciary. The press operates outside of that and acts as its own check and balance. That's why it's called the Fourth Estate. And it's important that the media be adversarial to the government. Not necessarily in a way that, like, say, lawyers for opposing sides are adversarial, or teams on a basketball court are adversarial against each other. The media shouldn't be fighting the government for the sake of fighting it, but they do need to be able to remain independent and push back when is necessary. And if we want the media and the press to be able to do their job effectively, we need to give them additional protection, because as we've seen, both in our history as well as in autocratic governments around the world, that one of the ways in which freedom of expression is stifled is to silence the media. And we know this from our own history, not only because the United States government has certainly done it. We'd like to say that we don't, but of course we did, right? There was a guy in the 19-teens who literally ran for president from jail because the government locked him up for being a socialist. You can have all the problems you want with socialism as a political ideology. But I hope we can all agree that if somebody calls himself a socialist, he shouldn't be locked up for it. But that's what our government did. And we rebelled against the British because they controlled the media and shut down Thomas Paine for writing Common Sense. Okay? So there is a history that comes with needing to protect press as an institution. Number two, media by and large has expertise that is above and beyond the average person. But then that's one school of thought, right? Founders wrote the press clause in there specifically. There are policy justifications for giving the freedom of the press additional protections. Therefore, journalists are protected specially. Now, number two, Chief Justice William Burger. I always like this name. He's not disagreeing with anything necessarily what Potter Stewart says in terms of the need for protecting journalism, protecting speech. The journalists have a special societal place in our democratic system. However, who gets to determine what is the press? We've already been skeptical of the government being able to determine what is true and what is not. Because if we let the government decide what is true, communism being a threat to democratic way of life would be taken as an absolute truth. The inequality of the races would have been taken as a fundamental truth for certain points of the United States government. Inequality of the sexes, inequality of heterosexuals versus anybody who's not a traditional heterosexual, right? We've already established that the government cannot be all that trusted with determining what is true and what is not. So are we going to let the government determine what is a journalist and what is press? There's no way that would ever be abused, right? There's no way that a president might say, you're real news and you're fake news. It would never happen. So because the government cannot be trusted to determine what is a valid journalist, what is a valid institutional press, because that's how we get essentially state-run media, then there is no special protection. Because everybody can be, because either you have to start licensing journalists, which has its very real policy concerns, very real potential for abuse, or anybody who acts as a journalist can become one. And this is how it was in 1978. What is very different about the media landscape now as opposed to 1978? It's why I'm able to teach to 4 of you guys in this class and 10 people online. The internet. We all know, we've all heard of online-only media organizations. I actually would hazard a guess that it is where the majority of you get your news is from is from news organizations that have never once printed a piece of paper, never once been on a cable platform. And so let's say that, and so because it was difficult in 1978 to determine who is a journalist, what is a press, what is a news organization, now it's impossible. Also, like I said earlier, framers could have meant that press was simply the means of communication, literally protecting the printing press. There's enough historical evidence that that is not what they meant when they wrote the First Amendment, that there was real concern from the Anti-Federalists during the Constitutional Convention that it would be used as a way to silence news organizations. And this is getting very nerdy because this is what I read on the beach because I am who I am. But a big part of the Anti-Federalist push against the Constitution was the abuse of Federalist governments at the state level, intentionally suppressing the distribution of Anti-Federalist newspapers and writings. And so there is enough evidence that this was an Anti-Federalist push to try and have a backstop against picking and choosing winners in news. But I think it's an interesting argument, right? I just don't happen to agree with it. But this argument was floated by a couple of Harvard law professors and a circuit court judge, so I'm not going to argue with them too much. It's just I don't particularly subscribe to that one. Okay, so because and just so you guys know, as we'll see, and as you guys read in Brandsburg versus Hayes, Chief Justice Burger won out. That if we are going to have a definition of the press, it's going to be pretty much as expansive as necessary until you get to the point that anybody who wants to be a journalist and can call himself a journalist gets to be a journalist. So if you guys go home, somebody wants to go home and start a WordPress account and say the UNCG Student News and start typing up their thoughts and opinions and distributing, rumor and gossip and all these other things, then congratulations, you get to be a journalist. And so I have these two newspapers, I guess, magazines. On the right is The Economist, right? And I'm a subscriber to The Economist. It's very old school and has been around since like the 1800s or whatever it was. And they are about as stilted, starched collar, traditional media as you can possibly get. So everybody would kind of agree that they are the media, they are the press. But on the left, we have something called The Sovereign. And The Sovereign is the official newspaper of sovereign citizens. Does anybody, and very few people do, so it's not something that you should be aware of. I'm curious if anybody is. Does anybody know what a sovereign citizen is? Yeah, so yeah, you're absolutely right. So these are people who don't believe. I don't know the full intricacies of. It is crazy, right? And I try to be as respectful as I possibly can of every opinion that exists under the sun. This is pants on head level crazy. It involves, believing that the government has, I'm pretty sure that they believe that the Constitution has been switched, like National Treasure, Nicolas Cage type switched at some point, which means that you need to have a particular type of flag in a courtroom, otherwise it's not valid. They routinely sue the government for, I believe it's upwards of $1 centillion. We have million, billion, trillion, quadrillion, I think, whatever the 5 is, right? 5 commas. Because they think that all taxes and everything that has ever been taken out is unconstitutional because the Constitution is invalid. And they're legitimately a terrorist organization, right? They will kill police officers who, it's not super common, right? They're not our greatest domestic threat by any stretch, but they've been known to kill police officers for pulling them over, or they're heavily linked to anti-militia or to militia movements, things like that. Anyway, a little off topic. They got a newsletter because, of course, every conspiracy theory has to have a newsletter that talks about how ISIS and global warming aren't real, and how 9/11 didn't happen, and just the kind of conspiracy theories you would associate with people like this. They are a magazine too. So when a court looks at, are we going to give special protection to these organizations or for the people who write them? Crazy Town Doomsday Prepper writing for The Sovereign is going to get the same protection as the guy who writes for The Economist and went to journalism school. It is also not limited to physical printing, right? We got Huffington Post, we got Fox News, we got some angry guy talking about Mortal Kombat on YouTube. These are all going to be some form of press, because press is a way in which both facts and opinions are distributed. Just because you're in the opinion section of the newspaper doesn't mean that you're all of a sudden outside the freedom of the press. And that's really going to kind of highlight, the difficulty that you have with using somebody like Kent Brockman as, Kent Brockman is a journalist, but Lisa Simpson isn't. At what point in the Huffington Post's lifespan did they become a real news organization? Was it when Ariana Huffington first registered the domain name HuffingtonPost.com? Was it when they got to 1 million viewers or readers? Was it when they incorporated? Was it when they hired their first staff? Was it when they won their first journalism prize? And again, should the government be in a position to be able to pick and choose? Because there's absolutely no way that the government would not abuse that, intentionally or not. And even if the government theoretically could do it in a even-keeled, content-neutral, viewpoint-neutral way, right? They kind of had this magic thing that says this is a real journalist and this is not, and it was able to strip away all bias, strip away all political leanings. Would the public buy that? Like, seriously, would the public stand for any sort of law that theoretically made MSNBC real journalism and Fox News not real journalism? Even if it was justified, I'm not saying it is, but even if that was justified, from a public perception standpoint and trust in the government standpoint, it creates real concern about people's ability to freely express themselves. Okay, so most of the time, this is not going to be an issue, actually. Because as we've just spent the past 6 weeks talking about, when you are a journalist, when you're a private citizen, you, me, and everybody else in this country says something, they are given expansive First Amendment protection. You can say something false about somebody, it can ruin their reputation, it can be absolutely proven to be false, and you can be shown to be the worst journalist, the worst student, the least educated person in the history of the world, and you still might get away with it, because that has how strong First Amendment protections are. You can be a Nazi in this country and march through a Jewish neighborhood, and you still have protections under the First Amendment. So these are expansive protections. So most of the time, journalists are already protected by enjoying the same freedoms that everybody else does. Here's the issue, though. Confidential sources. And confidential sources is something that we will talk a little bit about when we get to media ethics, about the ethics of using a confidential source. But they are certainly the backbone of investigative journalism in this country, as we'll see with this clip from All the President's Men. And for anybody watching this after the fact, when I post this on YouTube, I will probably have to cut this section out. But this is essentially, so if that does happen, this is essentially Bob Woodward meeting his contact at the CIA while he's investigating the Watergate scandal. So,
Where are you?
Stuck. Story is stalled on us.
And you thought I'd help?
I'll never quote you. I wouldn't quote you even as an anonymous source. I mean, you'd be on deep background. You can trust me, you know that.
Come on.
Can you tell me what you know?
You tell me what you know.
Hunt worked for Colson at the White House. Hunt was investigating Kennedy at Chappaquiddick.
That should tell you a lot. What else?
We're beginning to hear a lot about a lawyer at Crete named Gordon Liddy. Gordon Liddy, who was fired by Mitchell because he wouldn't talk to the FBI.
You'll hear more.
Will he talk?
I was at a party once, and a lady put his hand over a candle, and he kept it there. He kept it right in the flame until his flesh was burned. Somebody said, "What's the trick?" And Letty said, "The trick is not minding."
The story is dry. All we've got are pieces. We can't seem to figure out what the puzzle is supposed to look like. John Mitchell resigns as the head of Crete and says that he wants to spend more time with his family. That sounds like bullshit. We don't exactly believe that.
No, but it's touching. Forget the myths that the media's created about the White House. The truth is, these are not very bright guys, and things got out of hand.
Hunt's come in from the cold. Supposedly he's got a lawyer with $25,000 in a brown paper bag.
Follow the money.
What do you mean? Where?
Oh, I can't tell you that.
But you could tell me that.
No, I have to do this my way. You tell me what you know, and I'll confirm. I'll keep you in the right direction if I can, but that's all. Just follow the money.
okay, so stop. Okay, so for those of you who maybe aren't quite as familiar with Watergate and what it is, Watergate was broken open primarily because of Woodward and Bernstein's ability to use a confidential source that they called Deep Throat. This was somebody who was feeding them information, confirming and denying certain leads that they were following up on. And obviously, when Woodward and Bernstein wrote All the President's Men, as well as their things for the Washington Post, they weren't going to tell public who this person was. Now, why is that, right? Like, why would Woodward and Bernstein and any investigative journalist not reveal the identity of their source?
Confidentiality. Usually the attorneys won't reveal it because conspiracy, like in a way create or like self employment for themselves. People want this like more people come to them to get this news or this that nobody knows. So usually it's like income food or like people are just all the information and sell it to this company or stuff like that.
Yeah. So when you have sources, right, that increases your value as a journalist. Why does Adam Schefter, if anybody knows who Adam Schefter is, the ESPN NFL insider, why does he have like tens of millions of Twitter followers? It's because he can tell me who's trading for who and what this person is doing with this particular draft pick, and the NFL is a multi-billion-dollar company, so that makes sense, right? So that makes sense as to why a journalist would want to cultivate a confidential source. However, let's say you're Adam Schefter, and you are finding out from the assistant GM with the Philadelphia Eagles that they are going to trade Carson Wentz. Why are you not going to say, hey, I just got off the phone with, John Murray, and John Murray, assistant GM with the Philadelphia Eagles, told me that they're going to do this. Just wanted to let you guys know. Why would Adam Schefter not do that? Why would he not just tell you who's talking to him? Now, part of it might be from a selfish standpoint of Adam Schefter. He doesn't want Jay Glazer or these other people going and establishing the same relationship. But there's another reason. What would it be? Let's assume you're John Murray, the assistant GM of the Philadelphia Eagles. And this is not something that the Eagles wanted out there, right? They wanted to keep their trade rumors with Carson Wentz secrets. They could build up the trade, whatever else, right? What's happening to John Murray? He's going to get fired. You just told Adam Schefter what's going on, and our trade is blown up. That dude's gone. So confidential sources, and sometimes, it's just silly little things like, where's a football player going? When you're dealing with state secrets, when you're dealing with potential torture in the CIA, or you're talking about in the Cold War, when you're talking about spies and things like this, like these are real world consequences. And not only if you reveal who your source is or the source is found out, not only could they be fired, but they could be criminally charged. And if you know that's likely to happen, and you are a government employee who wants to reveal sensitive information, are you going to do that without any sort of special protection? Are you going to do that knowing that your identity is likely to be revealed and you be criminally charged and prosecuted? No, which creates an incentive. And so without confidential sources, it makes it almost impossible, absent some incredible bravery by individual government employees, to hold the government to account. But let's talk about a case that dealt with this on point. And one of the frustrating things about this area of law, if I'm being honest, is how little Supreme Court case law there is on it. There just is not a lot of guidance like you would see with something like freedom of religion or freedom of protest, right? It's not as robust a jurisprudence. It hasn't been fleshed out quite as much. But let's kind of give some facts for anybody who maybe forgot to read. Brandsburg versus Hayes, these are actually three distinct cases that are brought before the Supreme Court at the same time, kind of like what we saw with the cross-burning cases in Virginia versus Black. But they involve three stories, right? Like one of them was a guy who was admitted to a Black Panther meeting on the condition of anonymity because the government had classified the Black Panthers at that time as a terrorist organization. Another one was a guy who was following Louisville drug users around. This person is addicted to blank. This person is addicted to blank. These people use drugs, whatever. And again, using drugs is illegal. And so if you want to be followed around by a journalist, are you going to say, my name is John Moschini, I live at blank address, and I am doing the felony of injecting heroin into my veins? No, you're not going to do that. So without the condition of anonymity, you wouldn't be able to get this story. Same goes for admission to a Black Panther Party meeting. But anyway, all of these journalists wrote this story, and the local government all said, you know about crime. You know where and when crime occurred. And as the government who is responsible for investigating and prosecuting crime, we would like to know the identity of your People please. And the reporters refused to. The reporters said, nope, we got a First Amendment protection against revealing our sources. In the same way, doctors can, you know, oh, we'll get to that in a second, actually, sorry. Contempt of court, and so the court said, nope, I don't see anything in the First Amendment that says I gotta allow you to ignore a subpoena. I'm gonna hold you in contempt. And like I said earlier, contempt can include both jail time and fines until one of two things happen. Either the journalist complies with the subpoena and reveals their sources, or it becomes clear that jail and fines will not be an effective use of compliance, right? Because remember, contempt of court is not about punishment. It is about persuasion. It is about the attempt to, it's about coercion more than anything, actually. But if you're a journalist and you've been in jail for 3 years and you're not giving up your sources, at a certain point, you're just not giving up your source. And then the coercion is no longer effective. But the issue before the Supreme Court was whether journalists should have to respond to grand jury subpoenas the same way as members of the public do. Essentially, journalists have special protection. We've already established that there are individuals who have special protection. Yourself, for one. You cannot be held to testify against yourself. It is unclear, at least from my understanding, and it's not my area of expertise, but it is my understanding that certain pastors, right, if you go to confession, they can't force the priest to tell you what you were told, because that would infringe on freedom of religion. But there are some other classes of people who, if they receive a subpoena from a government that says, tell me about this, tell me about a conversation you had with somebody, that they can say, no, I'm not going to do that. And you can't force me to do that. Does anybody know other classes of people who have that power? You are looking at one here. I'm your lawyer. You tell me, yeah, no, I definitely stole those things. If the cops come to me and say, hey, did that person steal those items? Can I tell the cops? No. Attorney-client confidentiality, right? Doctors. Tell a doctor something? Now, there are obviously exceptions to that. You tell a doctor, Doc, just so you know, right after I'm leaving this office, I'm going to drive down the street and I'm just going to stab somebody. Like, I don't know who, but I just feel like stabbing somebody. I'm going to do that. They can report you, right? We're gonna make sure that stopping people from dying is going to trump your ability to have your conversations remain secret. The doctors, by and large. Anybody think of anybody else who can do something similar, where if a court says you got to tell me something, that they can say no? There are a lot of reasons people get married. And I'm betting that most people, when they do get married, the first thing on their mind is, I'm going to marry this person so that they can't testify against me in court anymore. But that is something, right? You cannot be forced, by and large, to testify against your spouse. So this is not unprecedented, right? We've already established that when we have a public policy concern, that in certain situations, the ability for the government to get information is less important than the ability to share information secretly. Now, the majority opinion kind of takes the arguments put forward by the dissent and by the lawyers for the journalists, because the court found against the journalists. And they kind of dismantle them one by one. Maybe effectively, maybe not. We'll see. The argument first was, without guaranteed protections, sources are not going to talk to journalists, and therefore the media is going to be less effective. That if you are a confidential source and you want to reveal government wrongdoing, that if you know that once this story is published that a journalist is going to be thrown in jail and be faced with the choice of either staying in jail essentially, most likely bankrupting themselves, bankrupting their publication, not being able to see their spouses and kids and whatever else for potentially months or even years. I'm sure there are a lot of really great journalists out there, but I'm not sure I'm going to trust one to give up several years of their life to protect my identity. And therefore, it disincentivizes and makes it more difficult and more treacherous for government whistleblowers to reveal government wrongdoing, which is the essential purpose of the press. That's the argument. However, the court said, look, this is speculative. This is entirely speculative. You have not shown real world potential for harm here. You're just kind of guessing at what might happen, and we're not going to buy that. And they also say that the government or that the press has been operating for, at this point, almost 200 years in the United States without this special protection, right? Like, New York Times has been doing just fine without the court stepping in and saying, you guys get this super speech, which is what the New York Times and other organizations are essentially asking for here, right? We are better than other people. We are better than other speakers and should be entitled to more protection than anybody else, which is a very big ask, and I don't think that should be overlooked. And the court said, where's the evidence of harm? You've been able to do your job just fine up until now. I think there are two, on a personal level, there are two problems with that. Number one, because by this point it's almost 200 years, for about 150 of those years, the First Amendment didn't apply to anything but the federal government. And so states had been abusing that power and had been suppressing speech up until very recently. So the majority's reliance on this kind of history of investigative journalism doesn't necessarily fly here. And number two, the court is being just as speculative as the journalists are. We know about Watergate. We know about the Bay of Pigs. We know about these government scandals, but how many do we not know about? And how many could we know about if we strengthen the protection for journalists as a constitutional issue? So I think that the court here, at least the majority, is engaging in kind of doublespeak. So, excuse me, that's the majority, right? 5 justices got together and said journalists are not entitled to protections. However, there is a concurrence from Justice Stewart, which has really made this case incredibly frustrating to read, because I don't know what the hell it says. And as we'll see with our oral argument, because this will be something that we deal with our oral argument, circuit courts, people with much more legal experience and went to much fancier schools than I did, can't make sense of this at all. Because you have 4 justices on either side, right? You have 4 justices saying there is no way that we're going to give special protection to journalists. The journalists are the exact same as everybody else. And then you got 4 justices on this side saying, no, the majority is wrong, that when the founders wrote the First Amendment, they intended to protect journalists as a special classification of people. And you got Justice Potter Stewart right here in the middle. And he said, right, okay, it's really too difficult to determine who is a journalist and who isn't. So you can't do that. But I have concerns here, right? I have concerns that what the court is today doing is allowing the government to essentially annex and deputize the press corps to do their own bidding. You want to find out who's in the Black Panther Party, and let's leave aside the severe wrongness of let's leave aside the civil rights abuses that are going to occur in that situation, because those are pretty clear. But anyway, you want to find out who's a Black Panther? You want to arrest them? You want to throw them in jail? You figure it out. Don't make some journalist from the Louisville Press-Gazette do your job for you. You're the police. And if we allow what the majority is suggesting here, left by Justice Berger, if we let them do that, then it essentially takes journalists and makes them sheriff's deputies against their own free will. And that is a power that is ripe for abuse by governments. Additionally, this decision has sent a signal to local governments that they can scare away confidential sources by being hyper-aggressive against journalists. And so not only are you running the risk of the journalist profession being singled out for special prosecution, but you're almost going to, by making them an example, you are going to scare away the do-gooders within your own government who are going to report on the abuses of your bosses. That's concurrence. Then you have this weird dissent from Justice Douglas, which isn't really joined by anybody. He's kind of off on his own little island. Douglas says that essentially there needs to be an absolute protection for journalists, because what Justice Stewart does is Justice Stewart lays out a rule, and he says, look, in situations like this, you need to have equitable balancing. There is a bomb in Times Square. The only person who knows where that thing is the food critic for the New York Times. Now, why a food critic for the New York Times knows where that bomb in Times Square is, I don't know. But if that's where the case, we should not be able to wave around the First Amendment and say, freedom of the press, freedom of the press, freedom of the press. We should be able to overcome that for the protection of people. So it can't be an absolute protection like we see with things like freedom of self-incrimination. Justice Douglas says, nah, screw that, right? Justice Douglas says there is no situation in which a journalist can be forced to reveal a confidential source. It is the same as the right against self-incrimination. Because, and I really do like, there's two reasons I bring this up. One, I think that this quote is really good, just because it does kind of summarize this Orwellian, we're always concerned that the government is going to be turned into 1984. It's kind of like, whether or not you think that that's likely or not, this hyper-libertarian, maybe not quite as hyper-libertarian as some people think it is, but it is relatively libertarian approach to government regulation of speech. It's coming from this idea of we don't want to turn into 1984. But the quote is that those in power, whatever their politics, want only to perpetuate it. Now that the fences of the law and the tradition that has protected the press are broken down, the people are victims. The First Amendment, as I read it, was designed precisely to prevent that tragedy. But if you open that door, you open that Pandora's box to this equitable balancing, as Justice Stewart is suggesting, as we'll see on the next slide, that the government is going to abuse that equity. The government cannot be trusted to they cannot be trusted to dispense that justice easily. So we should just take it out of their hands entirely. And that sounds crazy, right? That we should give the journalists absolute protection. But is it really any crazier than letting Nazis march through an Orthodox Jewish neighborhood? Is it any less crazy than protecting cross-burning as constitutional speech? Is it any less crazy than a lot of other things we've already talked about? Maybe not. And again, I'll bring up Douglas here in a second. So Justice Stewart in his concurrence laid out a proposed rule. Now, most of the time when I am talking to you guys about rules that have been laid out by the Supreme Court, it's because 5 justices agree that this is what should happen. 9 justices in New York Times versus Sullivan say that you need reckless disregard, and they all agreed on what reckless disregard means, or they all agree what actual malice means. Knowledge of falsity or reckless disregard for the truth, right? And everybody was on the same page. Here, we got one guy laying out this proposed rule. And it is super, super unclear as to whether the other 4 justices agree with him or not. But anyway, he lays it out anyway. He says that in order to successfully subpoena a journalist to testify, the government should have to show 3 things. Number one, that there is probable cause to believe the newsman has information that is clearly relevant to a specific probable violation of law. Number two, that the information sought cannot be obtained by alternative means less destructive to First Amendment rights. And three, a compelling and overriding interest in the information. Now let's take these things one at a time and what they are designed to prevent against. Number one, there has to be probable cause for a specific crime. The main concern that Justice Stewart has when he is enforcing this restriction on local governments and police forces or whoever else is that they can't just go on a fishing expedition, right? They can't subpoena the politics editor for the New York Times and say, tell me all about stuff you know. Who's been talking to you? What government secrets do you know? Tell me about how all your sources are. It has to be a specific violation of law, and the information sought has to be clearly relevant. It has to be targeted. So if you want to investigate who's in the Black Panther Party, you can't just say, give me your computer, journalist. You got to say, give me the information you know about who is in the Black Panther Party. It also has to be more likely than not. Probable cause means more likely than not. So it can't be a long shot. It might be, well, maybe they have information. They need to say with at least 51% certainty that the journalist has the information being sought. Number two, that the information sought cannot be obtained by alternative means less destructive to First Amendment rights. So you want to know who a journalist's source is? You want to know who's been revealing the information? Maybe do your own investigation first. Maybe see if anybody's been emailing that journalist from a government computer. Maybe if you are interested in who's in the Black Panther Party, which again, it's not a crime, but the government was treating it as one. That's a separate conversation. But if you want to know who's in the Black Panther Party, maybe do like police work, maybe do investigation, maybe talk to people, maybe try and get your own undercover person in there. This is safeguarding against laziness. And it's safeguarding against laziness disguised, it's safeguarding against abuse disguised as laziness. And number three, compelling and overriding interest in the information. There is a difference, according to Justice Potter Stewart, with making a journalist turn over the information. If we are trying to track down Osama bin Laden for bombing the Twin Towers on 9/11, and finding out what college kid is smoking pot in somebody's basement. Those are two very different things. And the government certainly has differing levels of interest in prosecuting them, justifiably. Justice White, also who wrote a different majority, he's the one who wrote the majority opinion. And he said that it is not a constitutional issue. The Constitution does not dictate this protection be given to journalists. But there is absolutely nothing stopping from the federal government in the form of Congress or state governments from passing their own protections, right? You want to protect journalists? State of California, protect journalists. Pass a law. Do your job as democratically elected legislatures. Because honestly, that's how I get my protection. I get my attorney-client protection not because the Constitution says so, although there might be an argument that it's constitutionally required, but it's not. It's the state of North Carolina saying, under these circumstances, you are given protection. Same goes for spousal privilege. Same goes for doctor-client confidentiality. Same goes for, in a lot of states, pastor-parishioner confidentiality agreements. So if state legislatures have shown the backbone to protect lawyers, doctors, and pastors, maybe they should also protect journalists. So the issue is not with us. The issue is with your state legislature. And importantly, Congress has the freedom to determine the fashion and standards and rules, and as narrow or broad as deemed necessary to deal with the evil discerned. We, as a court of law, are going to be really bad telling you who is and is not a journalist, who is and is not a news organization. But do you know what you elect legislatures to do? Make that determination for you. In the same way that the only reason I get to protect my clients when they tell me that they have done something wrong is because I went to law school, I passed the bar, and have not stolen from their trust accounts, which means I get disbarred. And the government says that, right? The government says that that's when that protection kicks in. And that is exactly what states have done. And it's actually shocking to me that this happened. And I don't think it would happen now, but it is legitimately shocking to me that this happened. Because how many state legislatures in this country right now do you think you could convince to give additional protection to journalists? I'm thinking very, very few. Because everybody identifies the media as a thing that is against them. They are protecting the powerful or corporate interests. They are liberals, or they are conservatives, or they protect bigots, or whatever you want to say, right? There's going to be a sizable portion of any population in any given state that just hates the media as a entity. I am the second most hated profession in the United States, lawyers. You know, number one, journalists. However, 48 states and the District of Columbia have passed some sort of protection for journalists. The exceptions are Wyoming and Hawaii. My theory for that, there's just not a lot of news happening in Wyoming and Hawaii, so they haven't really felt the need to do it. But this is something that both Alabama and New York agree on, Mississippi and California. But they vary pretty wildly, actually. Some of them are absolute. Some of them actually abide by Justice Douglas, including the state of Alabama. You can never require a journalist to testify. But in Alabama, it's only going to apply to newspapers, radio, and broadcasters. So the local CBS affiliate is going to get super protection, super speech. The local blogger, or even a news organization with all the same journalistic standards as this newspaper or broadcaster, is not going to be given the same protections. And what we will do is, I'm going to go over this quickly, and then we'll return to it at the beginning of next class to kind of reinforce it. North Carolina has adopted what is called qualified immunity. And qualified immunity means immunity but with exceptions. And they allow for journalists to be subpoenaed, but they actually adopt Justice Stewart's test. But before that, they have to define who's protected. Journalist is any person, company, or entity of the employees in the business of gathering, compiling, writing, editing, photographing, recording, or processing information for dissemination in any news media. Okay, what does that mean? If you are a journalist and are acting as a journalist at the time that you receive and disseminate the information, you are protected. So, in our original hypothetical, way back at the beginning of class, we had Kent Brockman, Lisa Simpson, and Barney Gumble. Kent Brockman, absolutely protected, right? Is he in the business of gathering, compiling, writing, editing, photographing, recording, or processing information for dissemination in any news medium? Yes. He's a news anchor, for God's sake. Number two, Lisa Simpson. Does she meet this criteria? No, she doesn't have any of the education. She doesn't have any of the qualifications of Kent Brockman. However, there's no qualification, there's no education, there's no requirement for a journalism degree. She's absolutely in the business of doing those things as well. Barney Gumble, he's a dude with a Facebook page that, as far as we can tell, has never tried to act as a journalist before. Therefore, not going to be covered. So, we will leave it there. We will come back next class, finish up our conversation about state law. We will then move into our conversation about student speech in the classroom. So if you haven't had a chance to read Tinker yet, please do. Otherwise, be on the lookout for your first legal analysis, which will be due probably by Monday. I'll probably give you all of Sunday and Monday to do it. And I will see you guys on Wednesday. Thanks.